The next topic for our consideration, and we'll have some good discussion on this one as well, is our work with the Digital Identity Working Group. I circulated a document yesterday to the Select Committee and to the members of the working group that we can use as a discussion piece. So if you want to bring that up. And Mary Beth, did we get that put on the web?
Mr. Chairman, that is Appendix 3-01.
Okay, Appendix 3-01 on the web. So those of you that are following along at home should be able to pull that up. And I'm going to pull my copy off of there real quick. And then we'll get started. Hopefully everybody's got that handy. Let's see, one moment. All right, so a little brief overview. The Digital Identity Task Force has spent a good bit of time having discussions. We actually have had several meetings since we last met. We've brought on some experts from around the world and appreciate their engagement and involvement. We're going to hear from Dazza Greenwood in a moment, and he's been involved. We've got Claire Sullivan on the line. Let's see, where is there? Scott David up there on the line as well. And so we've had some very good support. Christopher Allen has helped to organize this group and these experts, and I think we've come to a good place. So while we had long conversations, a lot of discussion, worked very hard trying to distill to a product that we can try and bring forward this legislative session, we end up with kind of a short initial product, and that's what I've asked Mr. Greenwood to walk through with us. And so Dazza, if you'll introduce yourself, a little bit about your background, and then we're going to be walking through this Appendix 3-01 as a little concept piece, so make sure everybody's got that in front of them. Go ahead, Dazza, please introduce yourself, and the floor is yours.
Great, thank you, Chairman Rothfuss and distinguished members of the committee and invited participants. My name is Dazza Greenwood, and I think you asked for a little background, so I'll take a moment to say I started in state government at the beginning of my career as counsel and then general counsel for technology in Massachusetts in the 90s, and was very active with legislation, including UEDA and other legislation. It's kind of in an unbroken chain to, I think, the innovation that's happening in Wyoming now. But the issues are different now, of course. And most of my focus in my career has been digital identity. That was something critical to solve in order to bring transactions online for citizens within state agencies. And since then, I've split my time at MIT, wearing my hat today, where I run Law.MIT.edu. That's the computational law kind of think tank at MIT, where we do more research and some teaching and consulting through civics.com. But I always consider myself to be kind of by and for state governments, because that's where I started, and I'm very happy to be with you today. So this work stream relates to developing a definition of digital identity in Wyoming statutes that could be used as a kind of a building block that could be referred to support and reflect more of the work that the committee is doing and across the statutes. And it is, I do believe, timely to have such a definition, because increasingly everybody's operating through our digital identities, right, in commerce, with government, in our personal lives. And yet it's the legal frameworks have fallen somewhat behind. So the translation to what to expect when we operate through a digital identity, as it were, is still unclear. We hope to start to clarify some of that. So I'm going to share my screen, if I may.
Yep.
Host has disabled attendees.
All right, one second.
Okay. And I'm just going to quickly run the committee, sort of catch the committee up on, there we go.
Try again, yeah.
Can you see this?
Yes, we can.
Okay, so this is part of like a 30-page document that the group has been developing as we've met, and I just wanted to highlight.
Dazza, I'll say though, we can see your whole screen, and I always find it better if you reshare and do it just to the window. Okay, that will work as well.
Thanks. As interesting as the rest of my screen is, here we go. And so this particular part was at least my first contribution, and it was going through top to bottom the existing Wyoming statutes and the Constitution, just to see if I couldn't highlight the areas where identity, or more rarely, some form of digital identity already appears, just so we can level set correctly. So notably in the Constitution, there's 4 words that really get to identity. It's resident, inhabitant, individual, and citizen. Citizen just comes up in your right to bear arms article. The other ones come up in multiple places. So there's a kind of a benchmark of how do you refer to individual people, humans, right now. There was a lot of things that were helpful, I think, in developing what would be I guess I'd say a proportional and a good fit definition in Wyoming statutes. I'm just going to highlight 2 or 3 of them and then run through the very rough discussion draft that we put together. One of them is that whenever person is defined, and this definition here is in your high-level definitions that define terms that will be used unless otherwise specified across all of the Wyoming statutes. That's 8.1.102. Person includes an individual, and this is not uncommon in other parts of the statutes and the regs and the case law. Individual seems to be the go-to to mean a natural person, a human being who is alive. I thought, although this didn't relate to humans, it was very interesting, your tax treatment, which is, I think, somewhat better than GAAP and IFRS with respect to the definition of intangible personal property. There's something similar, although we're talking about property here, not people. There's something to be learned here. Personal property, it lacks mass, cannot be seen, felt, weighed, measured, or otherwise perceived by the senses. It has no physical existence beyond its representational, beyond what's representational about it. Intangible property's value lies in what it represents. So there's some words there that we thought could be helpful. There's also just a question that we didn't treat in the current draft about, do you really want to scope this so it relates to Wyoming, people that are Wyoming citizens or residents or operating in the state of Wyoming or not? So some of the criteria with respect to residents we thought were worth taking a look at to ask whether that ought to or ought not to be part of this. And there's 2 others. Oh, marriage. Genetic is, there's a lot of identifiers, obviously, of identity. But with marriage, let me see if I can find that. It came up, excuse me. This is the last one I'll show. Here we go. This is another way to get at what is the essence of how you legally treat individuals at a very core layer. Obviously, in some of the earlier history, wives were considered akin to chattel or property, and that is terrible. But the usefulness of this is we start to see, as the law evolves, what's different when people are treated as people and no longer as property. And the statutes here kind of highlight that they may form contracts, incur obligations, liabilities that can be enforced against them, that they can sue and be sued. So these are some of the attributes, I would say, of the thing that has digital identity when it's a natural person. So we just kept some of this in mind in the back of our heads as well. And then I'll leave the rest as an exercise to the reader, but you can see our entire document if you like. So taking all of that, we developed, the last thing I wanted to show is it struck us that in terms of what to shoot for, this definition section at the top of your statutes, Title 8, 1.102, was that this would be the gold standard. to arrive at a really good definition. And you'll notice that these definitions are quite short and to the point. They just solve the thing that is needed for a definition to be used anywhere else in the statutes. This seemed to be about right. And you'll note that most of these definitions run between 8 and 30 words, and there's not too many of them. So the thinking was, at least as an initial target, to aim to have an insertion to that section for digital identity, and then to use that definition in other sections to say things about digital identity. Okay, so what might a definition be? Well, personal digital identity is is just a working thought, and I should also add that this version is something that the entire working group, I don't even think, has weighed in on. As we got prepared for this committee hearing, Senator Rothfuss and I, and Scott David and I, and Tieme Roguer and some others, just started iterating this document to the point where Senator Rothfuss felt there was something appropriate as a discussion draft to get started. So I hope that other committee members will weigh in with their views, and they may differ from this first attempt. But the defined term might be personal digital identity, and we could define it as it is the, I'll read through self-sovereign for the moment to see just the essence of it, intangible digital representation. And then we have this phrase of, by, and for, and then an individual, and through which they intentionally communicate or act. So just to break that down, we're taking best of intangible and identifying as digital, and that it's a representation, and now of, by, and for. So there's a lot of profiles about us, dossiers about us being compiled all around the web and the world that are about us. But what we're trying to say with this definition, which is that of a person, is that this is their identity, and it operates, from them and for them and by them. Individual, we think, you could say natural person if you wanted to get very technical. It seems like individual is well understood in Wyoming law as being a live human being. And then through which they intentionally communicate or act is just intended to get to when the intentional is critical here. So there's a lot of accounts and artifacts of accounts and functions and systems that may be doing things that are associated with a person. We wanted to identify that in this definition that that there's a direct kind of linear connection between the live person and they're operating through, like, deliberately, this digital identity of theirs. And it's not something that the chain of automation and autonomous actions is not so attenuated that it can no longer truly be considered like theirs for purposes of their identity, at least. Leaving aside things like automated stock trading or other systems people may choose to use, it may not be their identity that we're getting at. So we did a parallel construction with organizational digital identity, and then included track to the standard wording in the statutes. It's a representation of by for corporation, business trust, estate trust, partnership, limited liability company, association, joint venture, governmental agency, public corporation, or any other legal or commercial entity, and through which it intentionally communicates or acts. So why would you define this? Like, what's the purpose? Part of the thinking here was, like, there's a lot you can do with digital identity once it is a defined term, to be sure. Something that we felt would cause no harm and yet would also be useful is inspired by Title 40 and your Uniform Electronic Transactions Act enactment. And in that's more narrowly related to electronic signatures and electronic records. But the underlying rule of law is known as attribution. And that's basically, how do you attribute an electronic signature or record to a person that can sue and be sued? I was on every drafting committee meeting of this of the UITA working group in the 90s, and there were quite a few of them. This was heavily negotiated and reflects basic principles of common law and general commercial practice. And it doesn't say you need a private key. It doesn't say you need a particular implementation. It is very definitely technology neutral. And what it does say is that the act of a digital identity is attributable to an individual if it was the act of the individual. And now, how do you know if it was or not? And that's what you argue about potentially. The act of an individual may be shown in any manner, including showing the efficacy of any security procedure applied to determine the individual to which the electronic record or signature or other act was attributable. A security procedure absolutely could be public key based. It could also be other credentials or other forms of authentication. And you don't even necessarily need one. You just have to be able to demonstrate that this person did that act. And finally, with the parallel construction for organization, and then you come to, well, what does it mean if a person acted or communicated through a digital identity? This again is derived from UITA and the rule of attribution, and the effect of a record or signature or other act attributed to a person under this the prior two sections is determined from the context and surrounding circumstances at the time they did it, including and otherwise is provided by law. So are you necessarily creating a contract? Well, maybe. Were you 12 years old at the time? Maybe it didn't form a contract. Was it a fraudulent contract? So all the underlying substantive law still applies. All we're doing here is as narrowly as possible getting at creating a space for digital identity. And I'll just close by saying, why do we care so much about this right now? Well, Wyoming is demonstrably a leader in legal reforms and legislative reforms. I think broadly, I would say that assist in transition from the industrial age to an information age. And there's still a gap in our legal frameworks necessary to make that transition elegantly. Some of that relates to people and citizens who, under our constitutional scheme, are very important entities. It is citizens that must consent to be governed, for example, and who are the source of sovereignty. And there's no place for that in cyberspace right now. Cyberspace now is more like living between a public sidewalk and a retail store. We don't have anything like a home. We don't have an anchor from which we ever could express consent, despite the fact that the way things are going, we're going to be expressing consent and everything else through digital systems. We already are partially, and that's going to be ever more complete with every passing, year and month. So the part of the idea is to create a definition that can serve as that home base for people in the digital world. And then you can use it as a building block as you build out the rest of the statutes. So I think, and then we have some highlighted questions here, which I believe Chairman Rothfuss will walk you through, but I'm happy to take any questions as well. And I look forward to hearing the discussion. Thank you.
Thank you, Dazza. That was great. I'm going to layer on just a couple of additional thoughts, and then we'll go to questions. The first thought is there are a lot of trade-offs with anything that we chose to do here, and we struggled with a lot of decisions, but this is where we came to, and it's certainly a great place to start the discussion. You see that we intentionally separated personal digital identity from organizational digital identity. That was a struggle on how we would do that. They don't necessarily have to be separate, but we anticipated enough difference in the handling of a personal digital identity, which represents the individual, we started with corporate digital identity as the concept, and we decided that was a failed phrase and wouldn't capture everything we wanted, but that's kind of the concept, is corporations, entities, legal entities as organizational digital identity that would then be treated and managed differently. And we thought setting that bright line from the beginning so that we could handle them differently as we built would be the appropriate path. And this is, honestly, in my view, going to be kind of a challenge in some ways to maybe sell the legislature on, why we just want to come with a definition and enabling that definition, right? That's all this does. We set up definitions that create a foundation, and then we provide links into UITA so that those definitions are effectively substantiated within statute. They have legal standing. And that's the first step. We don't necessarily want to layer on all of the things that you can do with it, because getting this first step right is essential to everything that comes along afterwards. Our concern that Dazza and I and others have discussed is, well, is that going to be enough for the legislature to think, all right, well, this is worth doing, and you know, what's the killer app here? What are we trying to accomplish if this is largely just a definition? So that's something I think, you know, I want us all to discuss and talk about that, and understand that we can't accomplish everything in the first bill on digital identity. Nobody else has statutes on digital identity, and this is a really important thing to get right. So it deserves all of the focus, even though at the end of the day, it doesn't have a lot of bells and whistles. So I look forward to a good discussion. Senator Nethercott, please.
Thank you, Mr. Chairman. I just want to communicate my overwhelming support for the work. I think it's one of the most fundamental pieces, actually, that we can do that affects people's daily lives. And it really is something that needs to be addressed in the law. And I think that this takes just the right bite at the situation, right at our daily lives and the transaction of business and how we operate in the digital world. And so I just want to express my thanks to the working group, because it's clear to me the level of academic work that went into this. Not just kind of big picture concepts and we're trying to shove them into Wyoming law, but actually started with a real study of Wyoming law, understanding federal framework law with UITA and other pieces to dovetail in. And so we're gradually building this very measured approach to our ever-changing daily lives. And I think that's exactly what we need to be doing as a committee. And so even though this isn't necessarily, you know, transformational, it is exactly what is needed and continues for Wyoming to create the space for this and to be on the cutting edge and leaders in this time. So I just want to say thank you for the working group for what is incredible work and thoughtful work and measured work, and I hope to see this move forward.
Excellent. Thank you, Senator Nethercott. I appreciate that. Christopher Allen, go ahead.
Thank you. Thank you, Mr. Chairman. I really appreciate the group that's been gathered together. We have a lot of solid background and diverse perspectives on this. So first, I want to say anything that gets it down into a concrete form so we can begin to discuss the deeper parts of it, I think is great. So thank you, Dazza, for pulling that together. The one thing that I'm trying to puzzle out how to address that we had in our discussions that to me was important was missed, and I've added this to the comment in the master Google Doc, is that the decentralized identity community largely got together because of the abuses of surveillance architectures and things of that nature. So this doesn't quite fit what's going on, where there are many digital identities for you that were created by others and aren't under your control. So that's why we kind of played around with this self-sovereign identity definition. So one of the consequences of this is that there's all these parties who recognize you, remember you, respond to you, where the problem space of digital identity is where the abuses are happening. Whereas this definition is, because it's got, the representation aspect of it in, I think, which line is that? Someplace I have a cursor. It's the representation of, by, and for kind of implies an embodiment. There's lots of informal recognition tools, the AI tools, the things that de-anonymize people and their data and all that kind of stuff. So I'm not sure what the right approach is. So I like the definition for sort of the self-sovereign-ish half of personal digital identity. But then there's all that other stuff where there's these digital identities that people have for you that are abused, that aren't under your control. And that's the place where we really want a lot of the legislation is, to prevent people from doing bad things to you. So that's my initial remark. I hope Dazza and also our other members of the Identity Committee might help puzzle this out. Thank you very much.
Thank you, Mr. Allen. And we had a long conversation about that, and I saw Dazza raise his hand. So Dazza, why don't you address those specific concerns, which I think are very valid concerns, and we will need to find a path forward. But go ahead, Dazza.
Thank you. Agree. Very quickly, I got two main action items from what you said. Number one was we attempted to get at the idea of the individual human having real dominion over, or this digital identity being theirs with of, by, and for. You used a word there that is a very good word, and it was in some formulations that a person can demonstrate it's their digital identity by showing control over like a credential that operates identity or something like that. Ultimately, we kind of washed all that out to make it simpler, but maybe we should think, or the committee should consider inserting the word control somewhere near the middle of that, so that we can show the relationship between the digital identity and the person is that this is the one that they control, not one about them that represents them, but it's other people's control it and so forth. So that word control, I really do believe is missing, or at least the concept is missing, and that would be one of the indicia of what we're talking about. The second thing you said, which is more importantly from a public policy and legislative perspective at this point in history, is what do you do with it? And could people use it to begin to exercise some of their rights, for example? And we've discussed fair information practice rights of, deletion and control, give me a copy, that kind of stuff, CCPA kind of stuff. Our thought was to create a there that then in other parts of statute and other more specific discussions, you could refer to and start to imbue rights and perhaps responsibilities with. So I think that's terribly necessary, but it felt like a bite too much to create a definition.
Yeah, and I'll follow on. I was originally trying to get an or clause in extending the definition to get specifically at what Christopher Allen was discussing, which is the things about me. As there's the me, and then there's the things about me. And after discussion, the reality is the digital identity, if we want to structure it and you think of it as the analog of my identity is the me, and then there are things about me, about my identity. And so the structure we were looking at here is from that standpoint, where the personal digital identity is that abstraction of my identity that I control, that is the me. And then we will have to layer on, and we'll have an appropriate framework to layer on the concepts, Christopher, that you're talking about with regard to the about me side of things. And you see that's a discussion point that's actually the number 4 for considerations really is, how would we incorporate some of the self-sovereign principles into this framework if we want to add that to the Bill 1.0, and which things would we add and how would we do that? But there really are two ways that you can look at this. One is my personal digital identity the portion I control, or is it the portion I control plus all the things about me, which really are the primary concerns? We know that. But from an enabling standpoint, going with the Occam's razor approach of let's define the core of my identity and then layer on from there where we can separate that which is within my control from that which is about me being gathered and gets us more into what we would do that would emulate CCPA and GDPR and provide those protections of those things that relate to my digital identity seemed like a cleaner, certainly a leaner initial approach. So that was the motivation. Doesn't mean it's the right answer, but that's the motivation behind it. Go ahead, Mr. Allen.
Actually, I would love to hear from Claire first, just in case. But I just want to be in queue because I have a very specific thing on what you just said, but we haven't heard from.
Yep, that sounds great. And let's do that. Let's go around, and I would like to hear from Claire. Claire, what are your thoughts on this approach? Go ahead, the floor is yours. And please start by introducing yourself to the committee and a brief background, please.
Okay, all right. So my name is Claire Sullivan. I'm a professor at the Georgetown University Law Center. I run a cyber research center there called CyberSmart. So my specialty is digital identity. I did the first thesis in this area, looking at digital identity as an emergent legal concept. Won a Fulbright scholarship to come to the United States. Married my husband here, and the rest is history. I'm now living in the United States. You can hear from my accent that I'm Australian. So I'm part of this working committee, but I didn't see this definition until it was sent to us last night. I was a little surprised when I saw it, but the more I have thought about it, the more I like it. I think it's elegant in its simplicity. I think it's really workable. And I think it's a really good start, and it doesn't get caught up in sort of all the issues of exactly what is digital identity, what is its components. So I'm a big fan, and I like the separating out of the personal and the corporate. The emergence of a corporate digital identity is a really new area, and it's one that's rapidly approaching us. So I think getting ahead of that is important. Christopher, to your point about control, I understand exactly what you're saying, but in many respects, this is out of our control. I mean, I'm really assigned a digital identity for most transactions. That comprises my name and various attributes that apply to me, but I often don't get a choice in what that digital identity actually is. So I like this definition that it doesn't get into that it's really saying that I'm using it, I'm acting through it, I'm communicating it. And as soon as I do that, it becomes the means by which I'm represented digitally. So I think it solves most of the problems without getting into some really difficult issues. But I think the way forward with this is really going to point forward that there really needs to be some specific principles around all of this, of how it's managed, etc. And I think that gets to the kind of concerns that you have in terms of the self-sovereign part of it.
Excellent. Thank you, Claire. Appreciate that. I want to go to Scott David also.
Yeah, I don't have any comments at this time. I mean, I've worked with on the language a little bit with Dazza, and it's moving in the right direction. I think one of the challenges is going to be just in terms of introducing it to folks so they can see it in operation. And this has been alluded to already, is to just provide some use cases, to show them how it would work through and how that would be different than in other settings. But I think the ideas are moving in the right direction, and I think a lot of this is going to be, when you're trying to lead, sometimes you can lead by following also. And so for the state to be aware of what's going on in the out in the larger world within the United States and outside, I think is going to be very relevant to continuing to develop this so that it can be useful. Because my understanding is that this is intended to be something new and innovative. And so to innovate, we need to find those gaps, and the gaps are changing quite quickly. But anyways, I don't have any particular comments at this time, except to say that there's looks like there's good work being done, and I'm plan to continue to help out.
Excellent. Thank you very much. And Scott, I didn't ask you to introduce yourself briefly. Again, a brief introduction.
Sorry.
I know you, but it's always good to do that briefly.
Sorry about that. Yeah, my name is Scott David. I have been an attorney for 30 years in financial services in New York at Simpson Thacher, and then with Preston Gates and Ellis, now K&L Gates, worked in a lot of, basically my entire career I've been putting intangible rights into packages so they can be moved around, whether they're business type rights or tax rights or data rights and individual rights, intangible rights, etc. And so this is, to me, an extension of that. Is what does it look like? The famous painting, "This is not a pipe." Well, it's a realist painting. Well, the question is, what's the difference between the thing represented and the representation? And that's what we're struggling with here. One of the things I think that Oh, so I'm now no longer an attorney. I work at the Applied Physics Lab at the University of Washington, basically working on engineered policies. So the idea is to try to take law and treat it as engineering, and rhetorical engineering in a sense, story building. And so that's what we're engaging in here. So it's my pleasure to be working with folks here. Thanks.
Great, thank you. Thank you very much, Scott, and really appreciate Claire, Scott, Dazza, your work on this, and in joining, and Christopher Allen for kind of organizing and helping to bring this group together. I think we've got a great team that worked on this, and we'll keep working on it. But good job, everyone. All right, so with that, let's see. Christopher, do you want to weigh in now? Okay, go ahead, Christopher.
Thank you. As far as my introduction for this session, if you missed it in the previous, I know some people tuned in just for identity. Yeah. My name is Christopher Allen. I am with Blockchain Commons, which is a Wyoming LLC based on the new LLC laws there. And in particular, I'm a technologist. I'm the co-author of SSL-TLS. I am the co-author and sort of inventor of the decentralized identifier. I'm the former co-chair of the W3C credentials community, and very involved in sort of human rights identity and digital advocacy and privacy issues and things of that nature. So I am not a lawyer. I'm coming from the technology side, but I've also been doing this for a long time. So, you know, I have a lot of aspects of things. So one of the questions that I have for Dazza in this and the other actual lawyers is, you know, does it maybe make sense to sort of carve out to say that, you know, what you know, the credit bureau has for me is not a digital identity and should not be called. I mean, a lot of people say, well, they have your digital identity. They have all this information about you, which may or not be correct, et cetera. Is we be very, very clear that because it's not under my control and because it's, you know, X, Y, and Z, that it should not be considered a digital identity. It is personal identifiable information. But it very explicitly, because it's not under my control and isn't necessarily even fact, it's an assertion that it isn't, and that might address my concern that people are going to try to say all these things that aren't under my control are my identity, when in fact they're not. So I was hoping that might be one way to address my concern and still keep the current definition.
Thank you, Mr. Allen. And, you know, that really does get to the heart of our first consideration, which is the use of this phrase of, by, and for. And it's precisely that intent that is why there's an and there. We actually talked about the or. An or clause would be permissive and expansive. And then we could have had another or clause about all of the outside material being part of that definition. With the of, by, and for, the concept there is it has to meet those three standards, and that credit bureau information theoretically would not meet those standards. That was the intent of that drafting component. With that, I'm going to hand it over to Dazza, though, to talk kind of more about that language.
Okay, thank you, Mr. Chairman. Couple of quick things. One is, did you notice the way you characterized the credit bureau's profile on us? You called it a digital identity. This is expected. And so that was part of the idea of adding a third word. Not like I'm definitely not in favor of adding words whenever possible, but we tried to make a space definitionally for a term called personal digital identity. You could change that term, but I think some steps need to be made to distinguish this from other identity information that is not this type. The other thing is, I think the addition of a concept of control in a future draft, I think would also be helpful to distinguish between those two kind of situations you mentioned. We certainly don't control our FICO score. The other thing is, where would one make an affirmative statement that like a credit score and the associated information about people is not this? You know, maybe somewhere in Title 40. So as you start to build out what kind of rights, obligations, expectations people might have with respect to their personal digital identity, that sounds like a real good candidate to clarify what it's not. And then in the fullness of time, you know, one may be able to exercise more control over identity attributes, like, you know, akin to fair information practices, privacy laws, identity theft, you know, CCPA type stuff. And you can start to build out what the interactions are between an individual's personal digital identity and data that's about them, which may not be for them. It can sometimes be very hostile. I mean, by the most raw definition, like a special operations team, you know, demographic profile of somebody on a kill list is not their digital identity. It's happening to them. It's hostile. This is not that.
Thank you, Dazza. And Christopher, you know, that was one of the reasons why we've got in brackets the terminology that you've pioneered, which is the self-sovereign concept. And the self-sovereign certainly implies control and would capture that. The reason we didn't put it in the first draft is there was a little curiosity of whether self-sovereign is sort of too new of a term for statute, and whether self-sovereign would then somehow need a definition somewhere else, because I don't think we use self-sovereign, to my knowledge, elsewhere in statute. So it was another discussion point that we want to capture that concept and maybe control, since we use that elsewhere in property and it's in statute. I think there's probably case law surrounding it. I'll ask Senator Nethercott for her thoughts on that. But we want to capture that idea. It's just kind of a challenge to capture it concisely. So I like self-sovereign because I know what it means. I don't know if statute knows what it means enough to use it. So that was that was my thought in the discussion. And Senator Nethercott, what do you think about self-sovereign versus control and this discussion?
Well, I agree with Mr. Greenwood that there needs to be added in the concept of control. I do think that can be managed and handled. You know, self-sovereign freaks me out a little bit, just that term, you know. So, but I think this is the right space to bring it in and introduce it into Wyoming statute. There is nothing similar that I'm aware of. So I think we'll have support within the legislature for the term and the concept, and think that this is the right guiding subject matter to bring it in. But I think that there probably will be some initial hesitation too with any kind of terminology associated with sovereign.
Yeah.
The only, you know, just as an aside, the only other time sovereign is used is really in regard to governmental immunity, sovereign immunity, of course, completely unrelated here, but you know, that will be I think the similar concept that people may go to.
Great, thank you, Senator. Anyone else? Let's talk about the control concept a little bit. I see Caitlin. Hi, Caitlin. Go ahead.
Hey there. Thanks, Mr. Chairman. Yes, actually, Senator Nethercott, you're spot on. The concept of sovereign ending up in statutes, even if it's got the adjective self in front of it, I can understand that may be challenging. Where this concept of self-sovereign comes from is natural law. That essentially it's acknowledging the government doesn't define your identity. So many folks think that because we need a driver's license or a birth certificate, or in the US, a social security card, and that the government defines us, and that's kind of implying that the government owns us. So I think the way to sell this to the legislators is to appeal to natural law, and maybe instead of using the phrase self-sovereign, I completely understand where Christopher Allen's coming from. That is absolutely the phrase that has been developed in the in the digital identity world. That's more of a philosophy than I think necessarily a term. It's almost like, you know, using the term digital asset as opposed to cryptocurrency. It really is the same thing, but there's one that sounds more palatable than the other. And so, you know, we selected digital asset in the statutes. And I think a lot of the Wyoming legislators might might like the concept of using the natural law phrase that the government doesn't own you, you own you. And that might be helpful. Thank you.
Thank you, Ms. Long. That's a very good point. And going back to the natural law concept of self-sovereignty, it should be appealing if people don't find some other reason to freak out about it. It's appealing to me. I like the phrase. Representative Lindholm, what are your thoughts over in the House? How is self-sovereign going to play if we have that as part of the definition?
Like a drum, Mr. Chairman. That's going to speak to the heart of my former colleagues. I think honestly, it'll go well. You know, my only question in regards to how this all plays out is specifically, where was I, Mr. Chairman? You caught me by surprise.
No worries. I like to do that. When hands aren't raised, it's the professor in me, right? I'm looking at the person who's kind of staring off into space, and I'm thinking, time to call on Representative Lindholm.
Yeah, Mr. Chairman. So on the active individual may be shown in any manner, including showing up the efficacy of any security procedure applied to determine the individual to which the electronic record or electronic signature or other act was attributable. My question would be in regards to the UCC or UITA. How is that handled in regards to fraud or forgery? In regards to how will this work in regards to that person's individual identity when someone has hitched their mules to the wrong wagon, so to speak?
It's a good question. I'll give it to Dazza on that one. Go ahead.
Great, thank you. So that was the crux of animating a lot of the debate behind drafting of that clause, as I recall. And so the main fact determination is, was this the act of that person? So you mentioned forgery. You can think of, fraudulent impersonation, that class of kind of identity crime. So what we've set up here, just again extending forward from the pretty conservative rule in UITA, is like a criteria to determine whether something was or wasn't forgery, and that becomes a fact determination. If it was, then it's something that did not, then it would occur, from a different actor and not from that person through at least this formulation of digital identity. And if it's deemed that it wasn't, then the act would be attributable to them. And so they may have the obligation under that contract that was signed, for example. So the idea was to do minimal, or the goal was zero tampering with the underlying substantive rules of law and the current relationships between people, but to enable actions to occur online through digital systems.
Perfect. Follow-up, Representative?
No, Mr. Chairman, I think that's helpful. As long as there's not any kind of conflict in regards to existing law and how we're defining digital identity. I mean, I'm 100% behind what's been drafted here. I think it is a smart move, but it's also, I think you undercut it yourself, Mr. Chairman, as far as what the work of this group has done. This is far more. I think it's far more than just simple definitions. I think this really stretches its legs in the area we need it to. But yeah, it's going to be interesting to see how it plays out. Throwing in sovereign identity, though, I really like that idea. That'll trigger some thoughts.
Well, it's no fun if we don't trigger some thoughts. Thank you, Representative. Ms. Long.
Thank you, Mr. Chairman. Just to connect a couple of dots as well, the state GOP put out a legislative priorities, and one of which was prevention of human trafficking. And one of the interesting things, so this does play right directly into that. One of the interesting things I learned in working on digital identity at a UN conference a couple of years ago is that the first thing that happens when someone is trafficked is usually that their government papers are taken away from them. And in certain emerging markets, one of the most difficult things that when oftentimes a young girl, but not always, when the victim escapes, is proving their identity again and proving that they are who originally they said they are. This is one of the reasons why this blockchain technology is so useful in the human trafficking world, in especially emerging markets. What's happening is some non-governmental entities are allowing the parents or encouraging the parents to register on a blockchain some identifiable information about their child when the child is born, so that there's never an opportunity or a situation rather where if they do end up in a trafficking, becoming victims of traffic, that they can't prove who they are. So one of the things that I hated about this, and to be honest, this was something the UN was actually looking to try to fix, is that governments set the identity standards through these definitions. And if someone can't meet those identity standards, they lose their identity. And that's literally what happens to a lot of the victims of trafficking, because they've lost their government papers. And so I like the idea of going down this self-sovereign route, whether we use that phrase or not, precisely because you have to be able, when someone loses loses control of the evidence of who they are, they have to be able to regain that using a self-sovereign technique, a natural law technique, something along those lines. Thank you.
Thank you, Ms. Long. Senator Dockstader, go ahead.
Thank you, Mr. Chairman. I also agree it will trigger a lot of thoughts. My bigger concern is it'll take up a lot of floor time unless we lay some groundwork out in front of it.
Yeah. Thank you, Mr. Majority Leader. Yeah, and I think we can try and do that and just start with some early conversations, talk through with people. That's one of the beauties, I think, of this particular committee, is that we, as Representative Lindholm said earlier today, we've got plenty of horsepower on here, I think, to try and communicate what this is supposed to do, what the objective is, and allow that foundation to be built. So hopefully we'll be able to. And I do like self-sovereign. If it comes down to people uncomfortable with that particular phrase, we look for synonyms, and I think that's acceptable as well. But I think it's a nice starting point. Any follow-up, Mr. Majority Leader? Okay, thank you. All right. Christopher Allen, I see your hand up. Oh, I'm sorry. I'm going to go to Mr. Co-Chairman first. Mr. Co-Chairman.
Thank you, Mr. Chairman. Just wanted to weigh in a little more on the linguistical aspect of this. The lawyer in me keeps going back to sovereignty, and we've said it's going to trigger a lot of people or trigger a lot of thoughts, and I think that's accurate, and it's likely going to happen because you're right, the concept of self-sovereignty or even personal self-sovereignty, that doesn't exist in Wyoming statute. But what is really intriguing to me is that if you look across human history of jurisprudence, the concept of sovereignty is what we use to define our government. It's what we use to define our state, our nation. When we refer to sovereign immunity or refer to sovereign whatever, we refer to the government. So I think words matter, and choosing the word self-sovereign, and I don't want to get ahead of ourselves of abandoning that at some point, but I think we really should focus strongly on the concept of self-sovereignty, not just the concept of it, but the choice of words to use self-sovereignty matters here, because it really goes to the focal point of everything that we've been working on, which is a decentralization of how we view the corporate world, of how we view our government world, of how those two worlds interact, and quite possibly even on a much grander scale, how we think about our citizens and our people and how they interact with their government. And so I think just having a much deeper meaning to it, and I really like the terminology self-sovereign. I think that judges, justices will struggle with that concept for a very long time, as the word sovereignty is something that they use to think about the king's deer. So I'm excited to see this go forward. I'm excited to actually see the intellectual conversations that will occur, hopefully, on the floors. I also agree with Senator Dockstader that we're going to have to lay some significant framework ahead of it in order to get this concept from crawl to walk to run. Thank you, Mr. Chairman.
Yep. Thank you, Mr. Co-Chairman. And I'm going to go back to Mr. Allen. And we have public comment also on this topic, so I want to take that, and then we'll have some more discussion as well. But let's go to Mr. Allen first, and then we'll draw in some of our other public discussion. Go ahead, Mr. Allen.
Thank you. So, yeah, I mean, I coined the term self-sovereign identity for this purpose, you know, what, 5 years ago, you know, to try to start a dialogue in this. And as Caitlin has said, you know, this concept has been brought up before United Nations, et cetera. People have been, you know, struggling. Can't we come up with some other word for it or some other phrase or whatever? And everybody seems to so far come back to it. And I think it comes to the fact that, you know, there are under, you know, UN Charter of Human Rights and things of that nature, there are things that, you know, nations can't do. They can't take away that you're a person. And that's kind of the root of you know, the first principle of self-sovereign identity is that you exist. You know, you are a real person, whether or not your digital identity is all screwed up or not, you're real. And you deserve, you have dignity, and if anything, Wyoming is a very dignified state, you know. So I would really love to see, you know, Wyoming figure that out. If you can find something better than self-sovereign, I would love to see it. There are a lot of people that are looking for that, especially in more, you know, Europe is struggling with it as we speak. So thank you very much.
Thank you, Mr. Allen. All right. Any final thoughts or questions before we go to public comment? Seeing none, Mr. Marr, I see. Oh, I'm sorry. I'm going to go back to Dazza real quick, and then we'll go to you, Mr. Marr. Okay. Go ahead, Dazza.
Wonderful. Thanks. Quickly, number one, for what it's worth, I'm very much a fan of the concept of self-sovereignty. And as we've been chatting about in the side chat here, I think it's I don't think it's a new idea. I think it very well reflects the basic social and political contract that the nation, you know, has. It's part of our jurisprudence that sovereignty sources from the people. But then there's a tactical question legislatively of, you know, what do you want to do now? And, you know, it strikes me that one thing could be to just add the bracketed terms, maybe take them out of all caps of self-sovereign and leave it at that. And then another thing that could be done is to leave it as is and remove the bracketed term and then leave self-sovereign for another day. Another thing that could be done in either of those scenarios is look at the some of the principles that you, Christopher Allen, and others have started to build out with this more modern formulation of self-sovereign identity, and see whether those might be appropriate for another legislative vehicle in some chapter that relates back to this kind of more neutral definition, so that you're using the attributes on a more general definition and remain somewhat agnostic to how that's going to play out in the legislature or when that would play out.
Excellent. Thank you, Dazza. Joel, to you.
Thank you, Mr. Chair. I just wanted to add one thought that as we were working in the subcommittee, that was, you know, this isn't the appropriate sort of foundational level to include, but would just like to plant this seed with the legislators for further consideration down the road, which is I think there is an interesting way that this could tie back to Wyoming and Wyoming residency, Wyoming taxation down the road. If right now there really is, you know, other than a hunting or fishing license, there really is no definition of how you become a Wyoming resident. And therefore the distinction falls back on the state from which someone may be trying to abandon residency. And that's a moving scale right now, and probably going to start moving more rapidly. And we've seen some proposed legislation, for example, in California, which would be taxing wealth with a 10-year tail on it, regardless of where that person domiciled. So I think there are some great applications to build off of this foundation down the road that could be Wyoming specific, and just wanted to leave that thought. Thank you, Mr. Chair.
Thank you, Joel. I appreciate that. And yeah, I think that is a very good use case for identity is residency, and we can do a lot that I think will be beneficial to our constituents if we can clearly establish that, and then we can build other statutes around that and that recognition. So getting at the tax concepts that Mr. Ville was talking about, we can do that with this approach, and I think it would be a powerful tool for our people. All right. With that, let's open up public comment. Mr. Marr, go ahead, and please start by introducing yourself once again. Welcome back to the committee. We're happy to have you here, and look forward to your comments and participation.
Yes, thank you. Can everyone hear me?
Yes.
Wonderful. My name is Brendan Marr. I am an MIT Media Laboratory alumnus from 1998. I'm part of the MIT Computational Law ecosystem with Dazza. I am a Lao mentor, and I own 2 corporations and a series LLC in Wyoming. I'm going to make 4 quick bullet points and a bit of a conversation on what has been talked about today. At some point in the future, I may make a formal presentation, but I want to keep this short, considering that the last committee meeting, I went off the rails. So first and foremost, Wyoming, we all know, has done a tremendous job, but they are suffering from the Goldilocks paradox, because you've solved one of 3 problems. You have assets with identities and keys, but you don't have a way of representing individuals and or entities with digital representation. So that's why nobody is able to come in mass to Wyoming in these new kinds of digital ecosystems. And we'll see that as we work through these issues. The other point is file numbers and serial numbers and entity creation is critical and related to these discussions of identity. And Dazza has put forth a idea of name, rank, and serial number. And this idea of serial number is really important, because serial number is just like a file number. But if we think about these things as things that can persist on a blockchain, and in a way in which you can have that provable by a special kind of blockchain-based registered agent that proves that that identity is on the chain, whether it's for an individual or an entity, becomes really, really important. And it gets to Ms. Long's conversation of self-sovereignty, right? At some point, we need to be able to have an attestation that identity exists and persists in some form. And the most important thing here is the notion that is open-ended, that this persistence has many different forms. So it may be a key, it may be an IP address that persists. As long as it persists and we have a way of knowing that as truth, then we can connect all the dots. So I believe firmly that the ideas of a blockchain-based registered agent can play a big role in these matters, as Christopher Allen was suggesting, and as I mentioned the last time. But those are my points. But regarding today and today's discussion, I want to make this statement, which is, I think, really salient. And it is something that I've come to observe, which is one of the fundamental problems with the Series LLC, and it is related to individual identity, is that you have the problem where you don't have control. So the question is the asset something you have control over, or is it something you don't have control over? Because ultimately the question is about serving papers. Who do you serve papers on? What entity? And these things are all related. And I know Co-Chairman Olson's concern that we're not moving quite fast enough on these issues, but they're all related, and it is really, really critical to spend the time to define them in a way in which is open and allows for us not to shoot ourselves in the foot. Thank you very much.
Thank you very much, Mr. Marr. I appreciate the presentation and the discussion. Questions for Mr. Marr? So with regard to the series LLC, specifically the last point, you talk about the control aspect and whom to serve the papers on. Tell me a little bit more about what is a solution there, or what ambiguity do you see in place, and maybe a scenario or an example that plays out your concerns.
Sure. I believe one of the fundamental problems is that we have this idea of ownership of an asset, but we don't have the idea that that asset is an entity in itself. So again, we come back to the idea of a representation of an entity, just as we have the idea of a representation of an individual. And these things are the missing pieces, the two missing pieces that we don't have. And once we solve these things, we will be able to have a functioning system. So I do think that I lost my train of thought there, but I'll just leave it at that.
Okay, thank you. And I mean, so what it sounds like really is that you do see our specification of personal digital identity and organizational digital identity as at least moving towards enabling the objective that you're discussing, where there will be more clarity of the entity and its relationship to law, to statute, and to property ownership and other concepts. Is that a fair statement?
Yes, and we are making tremendous progress here, because I think what we've all hit upon is this idea of control. And in all cases, this is the crucial nugget, I believe.
Excellent. All right, thank you. And I see Christopher Allen has a question. Go ahead, Mr. Allen.
Sorry, struggling with mute buttons. So thank you. So I will say that in one of our earlier discussions, we did have the word "and things" in it, and we ended up pulling that out. And it was in regard to things like IoT devices and such. But I will concur that I have some similar problems. So I do have a Wyoming Series LLC that tries to keep all of the different intellectual property assets separate, so that the people who are working on intellectual property B are not liable for failures in series D or E or whatever. That's what the Series LLC law was all about. But it's really hard to be able to firmly say that this intellectual property belongs to C or E. But the same technology that I'm recommending that the Secretary of State adopt for use with registered agents and for identifying corporations, which is the W3C decentralized identifier standard, will work for not only that, but it'll also work for things and digital property and whatever, so that you can definitively say that not only is this cryptocurrency belong to a particular organization with a proof of funds and proof of all the same type of proof reserves stuff that the banks are now being required to do, individuals can do, and companies can do. Well, we can also do that around the more intangible assets, as well. So I think there's a there that there is this digital, the party that controls legally this intellectual asset, and being able to identify that and then be able to say, yeah, ever since 2021, when we registered it under Wyoming law, that is now a digital asset. There's also money there where just, like with liens and things of that nature, there can be a small fee for basically registering intellectual property or other different type of thing in this fashion, or register the fact that you actually own that Ring doorbell for a penny, and it doesn't actually belong to Amazon, which is kind of the way it is right now. That you ought to have control of your Ring doorbell, and maybe pay a penny to register it or whatever. So anyhow, I think there's some real possibility.
Yeah. Thank you, Mr. Allen. And we did discuss that. We certainly have had a lot of conversations about the things, the objects, the assets, and the fact that in the future, obviously, they too will have an identity, and there'll be ability to act upon them, potentially ability for them to act. And I think that's something that we need to tackle, but I'm hopeful that can be kind of a next tackle. And I guess I'd ask, is that okay for us to me, right now, the person and the organization are so deeply interwoven with statute and with statutory rights that they make sense for us to lead with. And then the concept of things having identity would be a future follow-on once we get this right. And that's my inclination, but I'm curious, does everyone else agree that that's an appropriate approach, or would it make more sense for us to acknowledge the identity of things, however we want to define things, or whatever that would mean at this time? Mr. Marr, I see you have your hand up, and I'm going to go to Dazza after that. Go ahead, Mr. Marr.
I agree to hold off.
Okay. Thank you. Dazza.
Thanks. It strikes me that the main thing to avoid in statute is an accountability gap for things with identity that are taking actions that may be creating liability, civil, criminal, other harms. I hate to be a downer because there's a lot of good and latent efficiencies and productivity and benefits to be had the more we enable and use these more automated and more autonomous constructs. It strikes me that the way we've framed things so far, the natural encapsulation of this would be non-person digital identity, because person includes natural people and legal entities, and then the trick would be to ensure that whatever is happening with these things has at least one legal entity that is responsible for those actions, so that there is a chain of accountability. And the story isn't like my lawnmower decided to run over your cat. It had nothing to do with me. Just it has a processor in it.
Right. And Dazza, I think right now you can get yourself almost anywhere you need to be if you were to form an LLC, use it as your organizational digital identity if we get to that point, and then put assets under it. So you can still get most of the way to current objectives for things if you want to through a two-step abstraction, and maybe down the road we can turn it into a one-step as that demand increases and as we potentially see value there. But I agree. I think right now our statute just doesn't necessarily anticipate your lawnmower running over the cat and then being responsible for it. Yeah, Scott, go ahead.
Yeah, I agree with everything that's been said here. One thing we certainly want to do is anticipate that day. One of the constructions that we're using in our work is quadruple A risk or quadruple A threat. And in that, we say there's 4 types of threat for humans: attacks, accidents, acts of nature, and AI or ML. And the attacks and accidents can be done by something that has discretion. So a corporation or a human can do things because there's an expectation of a duty placed on them. acts of nature are things that are harms that don't come from any kind of discretion. And then AI and ML are there on the end because we understand or believe that they are on the transition point between being inert and having discretion. So if you look back at the history of corporations, it's pretty interesting because they're just a bunch of people organized together, but they do have personhood legally. They do have discretion, even though there's no human behind it. And so one of the things for us to anticipate is that corporations are things, they're not people. I mean, yes, by statute, they're people, but they're not people. They're not human people. So we should anticipate that there'll be other inert objects and inert systems that will be given discretion, will have assets, can sue and be sued, all that nice stuff. So we should make sure that when we're doing this in the anticipation of having things be folded back in, that we have that anticipation, that we shouldn't make it difficult for us to then fold it back in. I tend to think that not from a legislative perspective, but from an analytical perspective, all three should be done at once. Because from an organizational perspective, we are talking about inventory control numbers. Social Security Administration looks at this as an inventory issue. And so there's a reality to that. So anyways, I just want to make sure we don't leave it unattended, even if we don't introduce it in legislation, that it should be something we clearly have a pathway to reintroduce it, because I think we're going to be doing that serially with new systems that will start to resemble corporate type forms and other organized forms that may hold assets and therefore be sued.
Yeah, no, thank you, Scott, for that. That's a strong thought, and honestly, let's just mark that also in our minutes, staff, and make sure that we're taking note of consideration for probably next year of digital identity of things and that concept, and we'll start exploring that more and making sure that we're not screwing it up and that we've got a good foundation in place. Co-Chairman Olson.
Yeah, thank you, Mr. Chairman. Just in case anyone thought I wasn't paying attention, that in Wyoming, when we talk about AI, we often think of something very different than artificial intelligence. When I was traveling last weekend to my kids' soccer game, my wife, who teaches in a rural ranch community, reminded me what AI means in our agricultural communities. Just a thought for all of our techies that it's confusing in Wyoming.
We're not talking old school Wyoming AI at this point. We're talking artificial intelligence as we're exploring Scott David's thoughts. Go ahead.
They are seminal discussions, however.
Well said. Who's got the rim shot available? All right, Mr. Allen, go ahead.
Yeah, I think, one of the key things that maybe we're not quite seeing is that one of the reasons why we're willing to give, some kind of personhood to a corporation is because of the registered agent, we're able to see who has control. And we're willing to do some things with digital assets right now because we can know who has control. We can demonstrate it. We can prove it. So for me, if you can't prove who has control of an intellectual property, then it isn't, it's an assertion, it's a claim, but it's not an identity. But there are these things that are emerging. So I think if we're very careful in how we talk about that, control ultimately legally ends up to a group of people, a group of, natural persons, even if it's, through a registered agent and, a group of people that have mutually collaboratively agreed to do something together. That's the only reason why a corporation gets these rights. This comes back to, that fundamental issue, and what Professor Maher said was, similarly there is a trifecta here, or a three-legged tripod is probably a better example, which you already have to a certain extent in the fact that you've defined digital assets, but you've defined digital assets without the ability for people to necessarily prove control, for individuals or corporations or other parties to prove control. Although you do require banks to do so. Thanks.
Thank you, Mr. Allen. Mary Beth, do we have any other public testimony waiting? I see on the list a Mr. Satterley, but I don't see Mr. Satterley in our room. So if Mr. Satterley's out there, now would be a great time to join for public testimony. And Mary Beth, anyone else that we're waiting on?
Mr. Chairman, that was it.
Okay. Well, Mr. Satterley, if you are out there, if anyone else is out there and interested in providing public testimony, please join now. It's almost lunchtime, and we'd be happy to hear from you. But with that, we do have just a few more minutes, and I'm sensing that there's general consensus that this is a reasonable approach that's been put forward, and that as a committee, we'd be interested in getting this drafted for the next meeting. So let's open discussion on that. Anything that we would want different from the drafting recommendations that Dazza presented, or any thoughts of what that draft should look like? All right, looks like we're in good shape there. Good deal. Well, let's do this by motion. Is there a motion to direct Legislative Service Office to draft legislation for our next meeting on digital identity pursuant to the drafting guidance that was presented today? I see a motion by Representative Lindholm. Can I get a second?
Second.
And I have a second by Ms. Long. All right, any discussion on the motion? Any discussion? Seeing none, all those in favor, please indicate so by putting your hand up in front of your face by the screen. All those opposed, please put your hand up by the screen. Joel, you're a voting member of that.
Then I would like to vote in favor.
All
Sorry.
right, very good.
I thought as a liaison I wasn't voting. I apologize.
No worries. One thing I will note, even though on the formal adoption of the legislation itself, and on motions along those lines that require it to be strictly legislative, then we'll do a roll call that will only include the legislators. But in keeping with our past practices, we want all of the members of the task force / select committee, the folks that have been involved, to be a part of these decisions. We always try and get towards consensus and unanimity. And so I want to make sure that everyone's comfortable with this support. So yes, on any motion short of a roll call, we'll get everybody involved. Thank you, Joel. It looks like it was unanimous, which is always great. Representative
Mr. Chairman, sorry.
Oh, go ahead, Mr. Chairman.
I did notice that Senator Nethercott was very eager to vote. She was in still frame mode. She came in a little late. I saw a hand pop up. Just wanted to make sure we recognize Senator Nethercott's vote.
I saw that enthusiastic aye vote. Absolutely.